Good afternoon, everybody. Tess Crawley here. How are you today? I am coming to you live this afternoon with a really quick little learning piece for you. And I'm just going to quickly share this into all my groups and so on. I've got a little itchy nose. But first, while I'm waiting for all this to load live, I wanted to say a very quick Happy Valentine's Day. I hope you're having a lovely day. I hope you're getting some love. Even if you have to buy it yourself, get yourself some chocolate. I think Valentine's Day is the perfect excuse for chocolate. And if you're not a chocolate fan, then whatever is your special little thing that you do to treat yourself, then today's the day to do it, I suspect. Right, I'm just sharing into. I want to quickly touch on a topic that I've been asked quite a lot this week and last week too. For some reason there seems to be a real flurry of legal action going on around all of those that I'm mentoring and supporting at the moment, including my own team. So I thought what I would do is a very quick learning piece on this topic, because I think if you're not familiar with what I do, you might not be aware that I am also a forensic psychologist. So I usually introduce myself saying that I'm a clinical and forensic psychologist. This means I've had quite a bit of experience in two key forensic settings. So the first, or three actually, if you count my research. So my clinical PhD in psychology was within a forensic field. I was looking at psychopathic traits in young women, which was quite a fun topic to research. And I also had the honour of being the only PhD graduate in my cohort who when the title of my thesis was announced, it was met with as much laughter as it was applause. I think for some reason people find it quite amusing to think of young women as having psychopathic traits, but there certainly are some who do. The other area that I then worked in the prison setting for quite a while. So had, obviously that's, a lot of people think of criminality when they think of forensic psychological work. But more recently, the key forensic area that I have been involved in has been to do with child protection and the family court. So you can imagine that child protection, but especially the family court, there's a lot of toing and froing between lawyers, and often there'll be requests from psychologists for provision of their notes. So this is something that certainly my team members and my supervisees really do find daunting when a lawyer contacts them and says, we'd like your access to your client's file, please. Here's a consent form signed by your client. Please produce the notes. Now, I think most of us have a very clear understanding that the provision of notes usually only takes place when there has been a subpoena. So subpoena is where the court has deemed this particular piece of evidence, i.e. your case file, is relevant to the matter at hand, or the lawyers for the case feel that it is relevant to the matter at hand that you must provide. So when you receive a subpoena, there are avenues for appealing. And in that case, I recommend you have some legal representation. So for psychologists, if you're a member of the Australian Psychological Society or one of the other representative bodies, you might not know that you actually have access to some legal support when something like this pops up. So as an APS member, using the APS as an example, if you're not a psychologist, just think about your own representative body and perhaps get in touch with them if you're asked by a lawyer to produce your notes. But using the APS as an example, you can contact the APS. They will put you in touch with a law firm in your area who is able to provide you with some guidance. Now, your professional indemnity insurance also is another way of accessing that legal support. However, let's take it back a couple of steps. When a lawyer asks you for your notes, oftentimes, I like to be generous. I like to think that lawyers just aren't understanding the process, or they're not understanding the sensitivities around release of client notes. Because, of course, if you think about a medical file, this is typically what lawyers are assuming. They're assuming it's like a medical file. So a medical file is going to have, quite scant information that is just to the medical facts. So presented with an itchy toe, prescribed ointment for toe, follow up if not cleared up in 3 days. Doesn't have all of the information that you and your GP have talked about, that what you got up to on the weekend and what you're hoping to do with your work and all those sorts of things that you might chat to your GP about. That's not going to be necessarily, probably not going to be in your medical file, but it might be in your psychologist's file, and lawyers don't understand necessarily, or are not aware necessarily, of that difference. Sometimes they actually are fully aware that that's the difference, and they're trying to get access to information that they might not otherwise get from you. So think about the process that lawyers are engaged in. They're trying to get as much information as they can to further their client's case. They're also trying sometimes to keep costs at a minimum. So if you can provide your file to them, it's a cheap way, relatively speaking, for them to get access to lots of information that might help their client's case. But it's not an appropriate thing for us to be doing, because of course we contain a lot of information in our client files that might not be relevant to the situation at hand before the court. So if you're thinking about a workers' compensation matter, are we talking about the injury? Yes, we might be, but are we also talking about their sex life? Is that relevant? Are we talking about their adjustment to a new baby? Is that relevant to the workers' compensation matter? So there can be lots and lots of information in our file that's not pertinent to the matter before the court. So a simple thing is to contact the lawyer who's asked you for your notes, remind them that under our code of ethics we are obliged to protect the case notes unless there's a subpoena. But we're more than happy to provide a report in answer to specific questions. So now, even if the lawyer says, but my client has consented, I would say that's not informed consent. So the client has consented to the lawyer, to you providing information to the lawyer to further their case, but it's not necessarily the same as you sitting down with the client saying, well, do you realise that if we release the whole file, we lose control over who reads what's in it? Are you aware that the notes in a file are much more detailed than what your doctor might be providing, and so on? So I would argue that the consent that a lawyer has gained from your client is not informed consent. It hasn't gone through all of the pros and cons of your case notes being released. So again, take it back to the lawyer, express your concerns. I welcome, and I would say, look, if it's a matter of money, you can negotiate that. You can negotiate whether it's a brief report or a brief letter answering 1 or 2 key questions, or if it's a more detailed report that's needed. You can provide a quote on how much it's likely to cost so that the lawyer and the client can plan for that. But don't go handing out your files unnecessarily, because it can land you and your client in hot water, and it's not in your client's best interest 9 times out of 10. So there's my simple answer. Don't be afraid. Ring the lawyer. Talk them through the issue. Talk them through your concerns. Talk them through what you are prepared to offer. And at the end of the day, reminding them, look, if that's not satisfactory, of course you have the option to subpoena me. That's a different process. They're not going to want to do that unnecessarily either. Lawyers don't tend to jump to subpoena quickly or unnecessarily. Okay, so if you've got any questions about how to handle those kinds of requests, do feel free to pop your questions into the comment section here. An aligned topic is when clients ask you for a character reference. So I might talk about that in a separate video, because I do need to rush off and grab my kids from school now. What I'd like you to remember is that within my professionals groups, conversations around these topics are private within those groups. This is streaming into all of my free groups. It's also streaming into my mentoring group, which is a subscription-based group, which you're welcome to look into. I have just popped I'm just going to pop into the comments section here my link to my mentoring group. Now the mentoring group, you can think about it like group supervision on steroids. So I'll be providing really detailed content within that specific group. It's a closed group. It's a group for professionals who really want to contribute to their own learning. And rather than more clinical content, it's about you. It's about you boosting your confidence. And that's why I call my groups the Quiet Confidence programs. So I'm popping that into the comments as we speak, which means I need to move this across a bit. And I will talk to you all again very soon. There it goes in comments. So if you've got any questions about this topic, feel free to ask, and otherwise I'll talk to you all again soon. And next time I might chat about what happens when a client asks for a letter for the court that is like a character reference, because that's always a tricky one too. Hope you're having a great Valentine's Day, and I look forward to talking to you all again very soon. Bye bye for now.